Mr. Weber, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or a household member. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Just so you know, I appointed you a lawyer yesterday. Your lawyer is here with you now. He is on Zoom. We're going to do probable cause now.
Yes, Judge.
Judge, I don't know if you remember, we did probable cause yesterday. You found probable cause, unless you want to revisit it.
I do, because I don't remember anything about it. And I want to be able to hear it with him so that we're all on the same page. Just real quick, if you don't mind.
No.
Okay.
Yes, Judge.
Please.
On March 4th, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with the complainant and the defendant, who both stated that an assault did not occur. The officer then met with a witness who stated that he observed.
Notice how multiple independent witnesses are giving consistent stories here? That's powerful for the prosecution. But here's the twist: without visible injuries, the defense will argue these accounts are exaggerated. What do you think? Should eyewitness testimony alone be enough to secure probable cause?
The defendant swing at the complainant 3 to 4 times. The officer spoke with a second witness who stated that the defendant opened the passenger door and punched the complainant 5 times. And when the complainant got out of the car, observed the defendant strike the first witness in the torso and shoulders. The officer then spoke with a third witness who stated that he saw the defendant strike the complainant 3 to 4 times with a closed fist and heard the defendant state he would fuck you up to the complainant.
Mr. Weber, I don't want you to have any contact with this person. Do you understand me?
In Your Honor, if I may, after having contact with the complainant and Sebastian for me as well, we would be okay with no threatening and harassing.
No.
Yes, Judge.
No. I don't want you to have any contact with this person. And I want you to understand now that I'm going to protect every person in my county, regardless of who they are, what color they are, they're a small farm animal. Do you understand? Don't have contact with this person. If I find that you violate these conditions, if I find that you become a danger to my city, if I find that you pick up a new case, I'm going to revoke these bonds and I will make them high. Do you understand?
Judge, if I may.
Please.
Judge, the CW was the one that came into court yesterday. She's a clerk for the Harris County district. She's a clerk there in Harris County.
Say it again?
She's a clerk there in Harris County.
The complaining witness is a clerk here in Harris County?
Yes, Judge.
Okay.
She's the one that gave us those affidavits yesterday that you showed me.
I understand, but I've got, go ahead. Go ahead.
She did not have any visible injuries. She states to me and to the district attorney that they were fighting over the keys and that it was just that it was mutual and that no injury occurred. She did not have any bruising again. She told that to the officer when she was arrested. Oh, I'm sorry, when my client was arrested. There were no visible injuries, nothing that would corroborate what the witnesses are saying.
There are 3 different independent, unrelated witnesses who see first 4 to 5 punches in the head, and then as he allegedly takes her out of the car, these same witnesses see 3 to 4 punches in the stomach as well.
Again, Judge, if that were the case, we'd have some injury, Judge. We don't have any injuries that are noted by the police in the report or by the CW when I saw her yesterday, or the prosecutor when he spoke to her yesterday, Judge.
Judge, just to confirm, yes, that's what the complaint told us as well. The same thing. There were no visible injuries, no bruising, and that's why I'm asking you, we'd be fine with no threatening and harassing.
Come up, ma'am. I want to make sure that every single person here is protected, and 99.9% of the time, I always like to follow what the complaining witness is meaning you, what your wishes are. Because, you know, I really take that into account. I have to be honest that from what the witnesses' statements say, it sounds really, really just aggravating and just, I don't want you to say anything. And so when I see something of this nature, it really takes me back. And that's why, you know, there's a method to my madness and why I do what I do, and to, you know, to protect you, because I don't want something to happen to you. That's because you're the person I care about. What would you like?
I have those affidavits in my prosecution for a reason. I never called the police. I don't know what they found.
I don't want to talk about the case. I just want to know what, do you want to have contact with this person?
Yes. We deal with a lot of things together. He didn't hurt me, so I don't know.
There is an order for protection that is in place now. I don't give a rat's behind what is going on. I don't care what stressors you have in your life. But if I find that you put hands on anyone, I'm going to put my hands all over your bonds and I'm going to rip it. Do you understand? I don't care what is going on in your life. You put hands. It's really not going to go well. Number one. Number two, the court order that I have now, the order for protection, says that you're not to have any threatening or harassing contact with the complaining witness. I don't care what you think is threatening or harassing. It's what she perceives. So can conduct in and of itself violate this thing? If I go like this, is that threatening or harassing? It is, and it will land you in jail. Do you understand? I will do what you wish, but if I find anything happens in the future that hands are put, threats are made, I'm going to yank the bonds and that's it. Okay. So if you guys want to do a rip now, I don't know if you've already done it.
We've already,
But okay.
It's fun, Judge.
So do you mind filing no threatening, harassing, no weapons? You're not to be in possession of weapons as well. Do you understand? Okay, take a seat for me while we get everything ready for you, sir. Good morning, Ms. Ford.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
I apologize. What's the last name you're on?
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
Yes, Judge. And the statement made statements stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her and no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol. And the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him. and finding the vehicle.
Wait, this is messy. First, she's in the tow truck passenger seat, now she's suddenly back in her own car with the engine running? These contradictions raise serious doubts. Do you think the prosecution can clean this up for a jury, or does this already sound too shaky?
Did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information.
Yeah.
So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy spoke of the defendant.
So someone sees her in the ditch.
Wait, is
I think you
that?
might have a different.
That's
Oh,
a
sorry,
different
that was
case,
the
right?
wrong case, Judge.
In this
Sorry,
case,
sorry.
she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint you a lawyer today so we can have someone take a look at the case for you, okay? Ramona, do you mind appointing someone for Ms. Moore, please? Just do me a favor, just take a seat for me in the jury box, will you, please? Okay, so it's a DWI, Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118. And
We have her in the passenger seat of a tow truck.
Right, so her statement alone isn't sufficient. That's all they have about her driving.
Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the traffic or the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that same, well, go ahead.
Have,
Go down to you until you get.
so do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the
Oh,
ditch
she
with the
wants it.
tire blown out. And the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not gonna corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah, yeah, I do.
Okay, well, give
So-
me time.
Yeah, and I'm willing to, if you want, maybe like we can revisit on Monday,
Okay,
because I want to give you time. I want to,
wait for her appearance? For Monday?
yeah, I'm going to put her under conditions though, but yeah,
Understood.
okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run her license, please? And any other prior DWIs?
Your Honor, no prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand? Okay,
Eligible, Your Honor.
great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign a reset, I'll have you meet with Fleischer if your bond conditions, and after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah,
Okay.
she needs to sign the reset, but yeah. Mr. Crump, you are charged with unlawful restraint. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 2:27 p.m., the officer was dispatched to a disturbance call in Harris County, Texas. Upon arrival, the officer met with the complainant, who stated that her child's father caused the disturbance and got her kicked out of the motel. The complainant stated her and the defendant got into an altercation due to the defendant trying to take a child away that they have together, and the complainant not wanting to be together anymore. The complainant was attempting to leave the room when the defendant began sitting against the door, preventing her from leaving. The complainant stated she grabbed the defendant by his hair and started striking him with a closed fist because she was in fear for her safety due to a previous offense report from Harris County Sheriff's Office. The defendant called his brother, and the defendant's brother entered the room and started recording the incident, and the defendant was trying to leave with the child, and the complainant attempted to get him away from the defendant. The complainant was unsuccessful.
This moment hits hard, because now a child's safety is in question. Courts take domestic disputes involving kids extremely seriously. Here's a question for you. Should the focus be punishment for the adults or protection plans for the child first?
And the child bumped his head on the door, and the complainant stated she knew the defendant by name, age, and sight. The officer was able to locate the defendant's driver's license and positively identified the defendant. Another call for service came from another location regarding an assault that occurred at the original location. Upon arrival, the officers met with the defendant, who stated he was assaulted by the complainant. The defendant stated they were having a conversation in the restroom of a hotel and that he was standing in the doorway when all of a sudden the complainant became belligerent and started cursing him, telling him to leave. The defendant stated he was punched in the face and suffered a busted lip, and the defendant stated his brother was called to mediate and be a witness. Then the complainant began cursing at the brother. The defendant stated the complainant grabbed the child by one arm and threw him on the bed like a rag doll.
Mr. Crump, I'm going to find that there's probable cause to go forward with the case. Did she ended up getting charged as well?
I do not see a charge for the complainant, Your Honor.
So just don't have any contact with this person. That's all I'm asking you to do. You know, sometimes when you have cancer in life, what do? You cut it out, because if you don't, it kills you. Some people in life can become a cancer to you as well. So that's it. I don't want you to have contact with this person. Do you understand? If I find that you do, I'm going to revoke your bond. I will put you in jail. I'm also ordering you not to be in possession of weapons as well, Mr. Crump. You have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay, I'll have you fill out an application. I'll take a look at it. I'm going to have you sign a reset with Ramona. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, come on. So can you file no contact and no weapons?
Yes, Judge.
Child.
A couple quick things I forgot.
Okay,
On the two clients I approached on earlier, I didn't ask you to sign the blood discovery orders. I've had.
I'll put them in. I'll sign everything for you.
Okay, I don't need one to show from you.
Is it the standard one, or is it?
Standard?
Okay,
Okay.
so some of the stuff that they've seen already.
We filed it. It's in your queue.
This is just a standard blood discovery.
Standard blood
Okay,
discovery.
Then I'll
order.
sign it.
You will sign them today?
Yeah, of course.
Okay, thank you.
Absolutely. Guys, can you put it in the queue?
Yes, sir.
For both clients?
Yes, sir.
I'm sorry, Judge, one of those was mine, one was David Smith, so if you see my name.
I got it.
If you can sign the other one as well, I appreciate it.
Yeah.
Judge, on Jamal Crump, you ordered him to have no contact with the complainant. They share a son together. Is there any way they could have a third party for visitation?
Well, of course, they can always use someone else, but I don't. Come up, Mr. Crump. I know that you're upset that they filed this case. But when I mean no contact, I absolutely mean it. They're going to call this person now to let them know of the bond conditions that have been filed. So if I get wind that you have contact with this person, then we're going to have issues. I get that you have a son and you should have, or a daughter, I don't know what it was, but you should have access because every father should have access to their child. And I want you to have access to your child, but you got to do it the right way. You know, use someone who like James saying, a third party. Don't take it upon yourself to try to do stuff because it's going to go sideways real quick. Maybe if you have parental figures like your mom, your dad, someone that she probably likes, right? If she doesn't like your brother, that's probably not a good person to use to try to get contact with the child. So try to find someone, maybe he can also help you too. Maybe he can help facilitate as well, where she drops off the child at a McDonald's somewhere, and then you come and you get the child for a certain amount of time, and you drop the child back off at a McDonald's. But don't do stuff your own way. Are we good? Okay.
Thank you, Judge.
Yeah. Your iFront, is it Shake?
Yes, sir.
Sir, you're charged with 3 cases. You're charged with terroristic threat of a family or a household member. You were charged with assault of a family member. You were charged with interference with the emergency request for assistance. All 3 of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Can I say something or no?
About the case, or do you have a lawyer?
Obviously, attorney, yes.
I'm sorry?
About attorney, and I need to discuss something, sir.
You are an attorney?
No. I need attorney. I need attorney.
I need hair. We'll talk later. Let's do probable cause first. You have the right to remain silent.
Yeah.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On February 23rd, 2025, in Harris County, Texas, the officers are dispatched to a threat to life call. Upon arrival, the officer met with the complainant, who stated that the defendant is her husband. The complainant stated that the defendant and her got into an argument, and that the defendant stated, "I'm not afraid of the police. I will grab that knife and cut your throat." The complainant then stated that the defendant had on November 16th, 2024, assaulted her. The complainant stated that the defendant grabbed her by the top of her dress, causing scratch marks, and punched her in the chest, causing bruising. The complainant stated that she attempted to call 911, but the defendant ended the call.
Sorry, thanks.
The terroristic threat was I'm going to grab a knife and cut your throat. Okay. Mr. Sheikh, I'm going to find that there's sufficient probable cause to go forward with your case. Do you have the ability to hire a lawyer?
So this also is attorney. Whatever money I have.
I'm not going to listen. You have the right to remain silent. Exercise that right. Anything that you say, they're going to try to use it against you to prove guilt. So what I can have you do is I can have you fill out an application. I will take a look at it to see whether you qualify. We don't give appointed lawyers like it's candy on Halloween. You have to qualify. And if you do, then I'll take a look. But I need you to fill out everything. As it stands now, I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You are not to go within 200 feet of where this person lives or where this person works. Do you understand?
Jamal Crump?
Do you see whether a order for protection has been entered in this case? Guys,
Let me see.
And Judge, the DVD prosecutor is on the phone.
Oh.
There he is.
that's
Yes, Judge, I was able to make contact with her. I'm not sure what the discussions were beforehand, but we're gonna be asking for no contact with to keep the whatever the residency restriction is in place right now.
she does not want to have contact with her. Okay.
And I don't see a protective order in place.
On the
I-
AFM, there.
Is there one in the
Yeah,
AFM?
yeah.
But I'm going to also do one on the
Terroristic threat.
terroristic threat.
Yes, Judge.
I want you to understand something and take me seriously when I say this, that when I mean no contact, I absolutely mean no contact. I don't care what's going on in your life. I don't care that you need clothes. I don't care that there's a child involved. I don't care that you need to go get the car, whatever it may be. No means no. And if you violate these court orders, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand? I am now entering in what's called a magistrate's order of emergency protection on the terroristic threat. This is a court order that identifies the complaining witness as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? This is what I'm saying, that if you violate this order, they can file additional charges against you. Now, Deputy Miranda will give you an application. I'll have you fill it out. I will take a look whether you qualify. Anything else you want? Oh,
No, Judge, I'm comfortable with no contact.
so can you also file the no contact and no weapons so that it outlives the, okay. Do not leave until you sign our additional bond conditions.
Yes.
Okay, please.